the good operation of international arbitration. So I guess I'll start again. Welcome, everyone, and to those online and streaming. This is the fourth session of World Arbitration Update 2024. We're here in Beijing, China, at the Beijing International Arbitration Centre, and very thankful for the hospitality and hosting of the Beijing Arbitration Commission, so we're very grateful. I was just saying that the topic of this panel is very central to the mission of international arbitration. We've titled it Efficiency Management and State-of-Art Practices of Arbitration Institutions. And as I was mentioning, arbitration institutions play an absolutely critical role in managing and making international arbitration effective. And of course, it's an evolving process. Institutions work to make the process as efficient as possible, working with arbitrators and practitioners, and providing a process that meets the goals and objectives of our users. We have, as I said, a great panel. Our moderator, Chen Fu Yang, will introduce our panel, but let me introduce him. He is the Deputy Secretary General of the Beijing Arbitration Commission, Beijing International Arbitration Centre. He is also the Vice President of the Asia Pacific Regional Arbitration Group, APRAG. He is a lawyer with an LLB from China University and has an LLM from Peking University. He was a visiting researcher at the Law School of UCLA Berkeley and has contributed greatly to international arbitration. And it's a real pleasure to introduce you today and to pass the baton on to our next panel. So Chen, Mr. Chen, please.
Okay. Thank you, Ian, for your kind introduction. And good afternoon, ladies and gentlemen. It's my privilege to be the moderator of this panel. As Ian has said, we indeed have a great panel, and we have 5 panelists from different arbitration institutions, and each of them actually you are used from time to time. And the theme of our section is efficient management, actually, but I will moderate this section in the same pace as other sections, because fortunately we have the same time as other sections. So, and I will first, we will start with the Luis Martinez. Luis Martinez is the Vice President of ICDR, the International Division of American Arbitration Association. He is also the co-chair of the American Bar Association's International Arbitration Committee, with over 500 members worldwide responsible for its strategic direction and business plan. And as the Vice President of ICDR, he served as an integral part of the ICDR's international strategy team and is responsible for international arbitration and mediation business development, and is also responsible for the case administration of international cases out of the AAA ICDR's Miami office, with a number of arbitrations that include sovereigns and state-related entities. So, Luis, could you provide with us with some update of the work of AAA, especially on the work related to efficiency improvement management?
Well, thank you very much. And let me begin by thanking World Arbitration Update and the Beijing International Arbitration Centre for inviting me to join you at this very interesting program. From the perspective of the AAA ICDR, I'll give you a few of our highlights. We are now approaching our 100th anniversary. We were established in New York in 1926. Very exciting times for the arbitration landscape in the state of New York. New York, a few years before 1926, had actually passed some pro-arbitration laws that were designed to reverse the then judicial hostility towards arbitration. And those laws, in fact, became the basis for the Federal Arbitration Act that we have today for the use of domestic and international arbitration. So New York has always been very important. And we were created by the merger of two arbitration institutions that were operating in 1925, and that created the American Arbitration Association in 1926. I'm proud to say that in the United States, we are the largest arbitral institution, largest in terms of employees. We have 36 offices. Also in terms of the cases we administer. We reached a very important milestone in last year, where we administered 500,000 cases in 1 year for the first time. We are comprised of 6 different divisions. We have construction, employment, labor, insurance. I am in the international division, and I was actually the first attorney hired when the ICDR was established in 1996. In total, we have administered over 8 million cases since we were established in 1926. In terms of just some statistics from the international caseload, last year we administered 848 international cases. We have 950 international cases currently pending. We are divided into teams. We have attorneys from different jurisdictions admitted to practice. We have Spain, we have an attorney from Russia, we have attorneys from Brazil working together. Most of them have LLMs. Although they have language capabilities, over 98% of our cases are conducted in English. In last year's caseload, we had parties participating from 93 different countries, and we had 100 mediations that were part of the statistic of the overall 842 cases. Mediation, the previous panel had discussed its advantages, which I totally agree, and one of the things we did when we revised our rules in 2021 was to make mediation obligatory. So when a case is filed with the AAA ICDR, we advise the parties that the first step is to go through a mediation. They can opt out of it, but we have seen a slight increase in the use of mediation, which our statistics are bearing out. In terms of the most frequent venues for our services and our caseload, New York was #1 with 121 cases seated there, and Miami was second with 91 cases seated there. And then we have cases throughout the United States and the rest of the world. In terms of efficiency, we'll discuss later, but a couple of mechanisms. We were the first institution to introduce access to an emergency arbitrator. And that tool has been very successful and adopted by many other institutions, and I'll chat a little bit about that later. And we also incorporated a set of expedited procedures. The expedited procedures, the international rules, mediation rules are all embodied in our international dispute resolution procedures, which you can find under ICDR.org, and they're available in 7 different languages, including Mandarin. I will chat a little bit about innovation and technology. We have a new president now that started last year. She was the former Chief Justice of the Michigan State Supreme Court. She is also a teacher in various law schools and highly committed to innovation and technology. She has been responsible for the focus of an internal team where we have staff constantly working on innovation and incorporating AI on various different fronts. And I'll go over some of the usages regarding how AI is being brought in to the arbitral system. Lastly, I will leave you with the perception, as we are to speak about efficiencies. This certainly is a very important topic to any arbitral institution. At the end of our cases, we always send out a client survey to the users, those that prevail, those that lost. But we do ask some questions about what do they think about the process, the rules, the arbitrators, the case manager. Would you use our services again, and what concerns do you have? And statistically, and it's been consistent, it continues to be time and money. So we have done a number of things to try to address the issue of time and costs, and I'll go into them later as we develop the topic further. But that's a little bit about the AAA ICDR. Thank you.
Okay. Thank you for Luis for giving us an overview of AAA and with very impressive case law. And, so I just wonder, do you have statistics on the average duration of your cases administered by AAA?
We do. There is a piece that we have prepared, and it's on our website too, on time and study and costs. And it really varies on the amount in controversy, but the average on the cases that are 5 million and above, the median time frame is between 13 months to 24 months. There's a big range in there, but so much of it is dependent by the parties. You know, our rules, when I spoke to you about efficiencies, we offer the parties many options. And it all goes back, and I think that'll be a central theme for me, because sometimes we are challenged with managing expectations. A party comes to us and they say, can you increase the speed? Can you offer perhaps doing this arbitration on documents only? Can the hearings be scheduled earlier? I always remind the parties that my hands are tied. If it's not in the arbitration clause that you negotiated, I have to follow the rules to the letter. The rules give the institution certain powers where the parties have not agreed to a step. Certainly all the gap fillers, every step is included to ensure that I can get from the initiation to the award. But in terms of efficiencies, I am limited by what the arbitration agreement says. So I tell frequent users, I tell in-house counsels, remember that you're in control. You're negotiating with the other side. You want to do arbitration without any hearings in person, before a sole arbitrator. You want to limit the document exchange phase. There's so many things you can do with an arbitration agreement. And I'll give you one site that I hope I leave you with. We have an application called clausebuilder.org. That's how it's spelled out. And if you go to that app, it takes you through how to design arbitration provision through an interview process. And as you answer the questions, it's giving you all the choices that you could possibly consider. And when you're done answering the questions, you can actually print out the clause that you've designed. Well, that clause, if you use it to negotiate with the other side and see if they'll agree to it, you've drafted a very successful and efficient arbitration provision. But when you come to the institution, keep in mind, I must follow the arbitration agreement or risk that the award could be challenged or vacated for procedural irregularity. So I have to follow the clause, I have to apply the rules. I can suggest, and I do suggest, many options to save time and money, but the user and the clause that was negotiated must be obeyed.
Okay, yeah, very key point. I know many users, they are concerned about the time and cost arbitration and expect the arbitration institutions to do more. But actually, as Luis says, it is in your control, actually, for the parties. So before going into deep further discussion, now I move to the second speakers, Yu Zhijin from HKIAC. And Yu Zhijin is the Deputy Counsel at HKIAC's arbitration team. She administers cases in English and Chinese and has acted as a tribunal secretary in administer an ad hoc arbitration seated in Hong Kong. She also assists in the operation of HKIAC's Shanghai office in China-related matters. So please share with us some update from HKIAC.
Many thanks to Dr. Chen for this kind introduction, and good afternoon, everyone. My name is Zijin Yu, and currently the Deputy Counsel at Hong Kong International Arbitration Centre. So first of all, may I express my gratitude for inviting me to this event and this esteemed panelist. It is also my pleasure to share some personal observation and on HKIC's experience and the recent practice on efficient case management and service innovation. So as you may know that during ICAO Hong Kong 2024, HKIC is pleased to announce the 2024 administered arbitration rules. As the fourth edition of its administered arbitration rules, I have to say the overall aim of the amendments is to improve the time and cost efficiency of the HKIC arbitration while maintaining the light touch administration for which HKIC is known. So we still have four key procedural mechanisms available for complex multiple-party, multiple-contract arbitrations, namely the commencement of a single arbitration under multiple contracts, joinder, concurrent proceedings, and consolidation. Also, the 2024 rules include expedited proceedings. I would like to echo with what Luis said. So the parties can use the EP procedure to fast-track the disputes. The EP award is required to render within 6 months after the constitution of the tribunal. In addition, the 2024 rules enhance the tribunal powers to determine preliminary issues or otherwise adopt procedures to decide the case efficiently. And we offer the parties early determination procedure, which allows the party to have point of fact or point of law that are manifestly without merit decided in a separate and swift process. So for institution, the new rules requires, So for institutions, the 2024 rules introduce additional tools that enhance HKIC's power to preserve the efficiency and integrity of the arbitration proceedings, including, that in very limited and only in that exceptional circumstances, HKIC may revoke the appointment of the arbitrator who cannot fulfill his or her functions, but it's a very limited and very exceptional circumstances. Last but not least, the new rules requires a more strict time limit for tribunal in respect of the closure of proceedings and rendering the awards. In particular, the tribunal is required to declare closure of proceedings no later than 45 days from last directed substantial oral or written submissions. From such closure, the tribunal has to render the award within 3 months, subject to extension as per the parties' agreement or by HKIC. By the way, we expressly allow for the use of an online system for delivery and the storage of all documents in arbitration. Since 2021, HKIC also have offered parties the benefit of HKIC Case Connect. It is an online case management platform developed for the convenience and security of parties and the tribunals. So now that we explained all the benefits, we really look forward to working with you under our new rules. So by the way, the new rules will take effect on 1st June 2024, the next month. Then comes to my second part as the service innovation. So I would like to share that I remember that around 3 years ago, HKIC signed a Green Pledge to support the campaign for greener arbitrations, so which seeks to raise the awareness of arbitral communities' carbon footprint by working with all the stakeholders to promote the best practice in managing arbitration in a sustainable way. Over the years, HKIC has made efforts to adopt more sustainable behaviors, like all documents are stored electronically on a security platform. Parties and tribunals are encouraged to submit documents by electronic means only, and the use of HKIC can connect. We also have one sentence in our signature of all HKIC staff at the bottom of the email stating that please consider environment before printing this email out. So besides, we implemented guidelines in our marketing activities to minimize single-use items, eliminate plastics, and adopt digital promotion for all events. We also organized events with virtual participation channel to reduce travel for the conference. A practice that I have to say continue long past the pandemics. I think I might stop at here and look forward to next distinguished panelist. Thank you.
Okay, thank you, Zhijin. As SKIC take the position of a light touch administration, so in that case, I think the efficiency mainly depends on the arbitral tribunal. So do SKIC has some mechanism to encourage the arbitral tribunal to raise the efficiency?
Oh, yes, thank you for your question. So I think not only in HKIC arbitrations, in general in foreign arbitration proceedings, and the tribunal may use the procedure order number 1 as a tool to improve the efficiency of the arbitral proceedings, because so in HKIC arbitrations, the parties and tribunal play a very important role in managing the arbitration proceedings, and they may negotiate, the bargaining and negotiating the time procedure adopted by and in DPO1, the length of time for pleadings, how many rounds of the pleadings, whether document production is needed in these proceedings, or whether the hearing is necessary. So I have to say the duration of the arbitration proceedings in HKIC arbitration or other foreign arbitration proceedings is transparent and predictable. That's all from me.
Okay, thank you. And our third speaker is Ms. Du Fei. She's the Director of Business Development Division of CTAC, responsible for the business development initiative and international cooperation of the organization. Ms. Du joined CTAC in 2003 as a case manager and has administered or supervised the administration of around 1,000 cases, both domestic and international. Fei has been an arbitrator since 2014 and has heard disputes of diverse natures. She's a member of editorial committee of the arbitration and law and has made representations representing CTAC in international meetings. So, Ms. Du, please share with us the recent development of CTAC, especially in particular related to the efficiency improvement.
Thank you, Fuyong. I will first of all thank our World Arbitration Update and as well as Beijing Arbitration Commission for inviting me to join this esteemed panel. Well, a very good afternoon to all of you. For the new developments of CTAC for the past few years, first of all, I would say half of the time we were going through the COVID, whose influence was pervasive. But fortunately, CTAC development was not that impaired. Statistics show that the caseload increased steadily, actually from the 3,333 in 2019 to 5,237 in 2023. And the amount in dispute has exceeded 100 billion RMB yuan for 6 consecutive years, reaching 150 billion RMB, that's $20 billion US dollars in 2023. So the amount in dispute for each case on average reached actually 280 million RMB, that's $40 million US dollars. I think the reason for this strong momentum of increase may be multiple, but I would like to actually give great credit to the adoption of technologies. As early as 2019, right before the COVID, CTAC has already developed our own online filing system, which allows the parties to do the registration online. So, and also in 2020, in April, we immediately put into use the intelligent hearing platform right after the outbreak of the COVID. So that means the restriction of travel and quarantine at that time actually did not prevent us from either accepting the case or having hearings for the parties. We can see that, this platform, Intelligent, I would like to do some elaboration on the introduction of the platform. It's a tailor-made, actually, hearing platform, unlike the commercial conference apps. It has some special functions for arbitration hearings. For example, the facial scan function to help to certify the identity of the parties, and also the real-time transcript recording, I mean, just like what we're doing now, for the whole process of the hearing. And also have the e-signature function. For example, on one hand, it will help the parties to sign the record on the spot, on the other, if they could reach settlement agreement in the process, then it will allow them to sign such agreement remotely. I mean, even when they are not in the same room. So with the help of the technologies, I think our cases, administration and acceptance were not affected. In 2023, we have 1,804 cases filed online and 1,632 hearings conducted through our intelligent hearing system. Well, another aspect of our development, I would say, would be the stronger international feature of our cases. We usually CTAC accepted international cases like 600 to 700 each year, but that does not include the cases where Chinese parties with foreign investment. I mean, when the foreign invested Chinese company was involved in a case, usually they would regard it as a Chinese company, and such case was categorized as domestic cases. So if we take into consideration with the foreign invested Chinese company as well, then our international or foreign related cases, I mean, the number will reach probably 2,400 each year. And yeah, similar to AAA, I would say throughout the years, because we were established in the year 1956, throughout the years, the parties of our cases actually have been from over 160 countries and regions. But in the year 2023 alone, 88 countries and regions or jurisdictions were involved, while with 62 cases with no Chinese element at all. Well, English was used in 93 cases, and also 136 non-Chinese arbitrators were appointed in 225 cases. There were 90 cases where there was no Chinese arbitrator sitting in the tribunal at all. And also there are 22 cases where the arbitrators actually were appointed from out of our panel. You know that China has adopted a panel system of the arbitrators. So CTAC actually in our rules made a breakthrough to allow the parties to appoint arbitrators out of the panel, subject to the confirmation of their chairman. Well, the third development I would say worth mentioning is the amendment of our arbitration rules, which has been effective as from January 1st this year. Well, there are more than 30 places or points being revised. Well, mostly I would say on the adoption of technologies to prioritize electronic means of communication and optimize the proceedings, for example, early dismissal, and also the exclusion of newly added attorneys to avoid undue delay of the proceedings, and also the disclosure obligation of third-party funders, as well as the, adding contract in the process of the arbitration. We used to have like joiners, multiple contracts, as well as consolidations. But in the new rules, we also allow the adding of a additional contract in the process. So that's the three, I would say, basic development that we witnessed in the past years. As for what are the methods to increase or to improve the efficiency of our proceedings, first of all, I would say, contrary to HQIC practice, the institutional feature of arbitration administration itself is a guarantee, I would say, of efficiency, because we assign a special or a particular case manager to follow the whole proceeding from the notice of arbitration until the conclusion of the award. He or she will serve as the tribunal secretary and also the facilitator of arrangements, as well as the alarm clock. I mean, in the process of the arbitration, he or she will remind the tribunal of each timing of the procedures and to avoid unnecessary delays. So with the help of such a case manager, I think the procedure can be assured, the efficiency. Well, a second, I would say efforts would be the harmonization of the Western and Eastern practice in arbitration proceedings. By harmonization, I refer to, I think in the morning session, a lot of speakers have touched upon the guidelines on evidence of CTAC, which actually give some predictability to the way to produce evidence, and also to give the parties chance to give some light discovery, some light like cross-examination, to avoid some ambush and the messing of the procedure. And also we have adopted a guideline for presiding arbitrators, which encourages them to use like the pre-hearing meetings, procedural orders, terms of reference, and also those tools, little tools, which are regular in the Western practice, however, are not that regularly used in China. So we encourage such harmonization of practices in order to streamline the proceedings and to give more efficiency and predictability to the process. Another worth mentioning, I would say, practice is the combination of mediation and arbitration. I think this is probably different from your med practice because, in our process, the arbitrator will switch his role into the mediator. I know it can raise some criticism or skepticism as to whether it's against the due process, whether it's against the procedural justice. However, such practice works very well in China, and because it saves time. You do not have to have a separate panel of arbitrators to hear your case. And, but of course, we have some preventing measures. For example, if in the process of mediation, we do not allow the recording of the whole process, and if the mediation fails, all the statement by either of the parties cannot be quoted or invoked in the later arbitration proceedings. But the reason I think such practice can work well in China because, the Chinese actually value a peaceful and harmonious once-for-all resolution more than any other concerns. So I think that can account for another, I would say, measures to facilitate the efficiency of the arbitration proceedings. Because of the time restraint, I will just stop here and to see whether later we can have further discussions on that.
Okay, thank you for quite comprehensive introduction of the measures the CTA have taken. have taken to raise the efficiency. And Fei especially emphasized the application of technology and also introduce the case management system. And I know actually HKIAC also developed its own system. For AAA already have system so many years ago. And for other many organizations have their own system. I also heard a complaint from the user. They say, you know, each time when I do case in a new organization, I have to learn how to use this kind of system. So what's your comment on this? You mentioned the harmonization. So is it possible to harmonize the use of technology in this field? Suppose we have the common use system that every institution use.
Well, while a new technology is introduced in, of course, we will take time for the users to get used to it. At the very beginning, when we first used the online hearing system, yes, some of the parties just refused to use it. They insist in being restricted in their small room and wait until the documents was allowed to be delivered. However, there are some, I would say, braver parties who would like to give it a try. And gradually you will find, you know, that people are accepting more and more this new approach of having hearings. And also it's a process, you know, at first the courts, I mean, the courts who have judicial review power over us are skeptical about this approach. We even receive some like judicial advice as to whether it's in line with our rules or not. But then gradually we, you know, the courts themselves are using a lot the online hearing as well. So for each, I think, new technology being introduced in, we should be patient and allow them to develop naturally. Thank you.
Okay, any panelists have a quick comment on this point?
I will just say that I think it will be hard to have, for the immediate time being, a universal system. Many of the institutions have designed their own proprietary platforms that are designed for the applicable rules. But what remains to be seen, for example, we're in beta testing AI to do a number of things, perhaps really assuming the role of a tribunal secretary. One of the things is automated procedural orders based on the first preliminary hearing. We are introducing AI tools to assist parties in filing the case and all the issues that can arise. Obviously, this is evolving in leaps and bounds, so I couldn't tell you what's going to happen from here in 5 years, but probably with the use of AI assisting parties through the platforms, perhaps that's the universal application that we may see.
Okay, with the use of AI, we expect if they could learn different system, it can handle everything, they would be better. Okay, let's move to the next speaker is Ms. Xu Suosheng, the Director of Cooperation in Development Department from Shanghai International Arbitration Centre. She has rich experience in arbitration business promotion and arbitration case management, and she would like to introduce the SHIAC, they call SHIAC's effort in efficiency improvement.
Okay, yeah. So good afternoon, everyone. So I'm very happy to hear because it is a good opportunity for me to reunion with my friends who I met in ICA Hong Kong. And also I'm very appreciate for BAC and WAU to well organize the seminar. And firstly, I would like to go back to the AI, the topic of AI, because SHIAC share the similar practice with CTAC and HKIAC and AAA. Because I think it is a very interesting topic, because I remember that we talked about AI and combined with arbitration in Hong Kong, in our office. because SHIAC launched our Hong Kong office at the end of last month. And we have the common sense or the common ground that under the unsatured mode, I think that there are no explicit prohibits, to use to utilize the AI, and this is a pre-condition. And secondly, but there has another meaning that unsatured rule doesn't explicitly prohibit the use of AI arbitrators. They indirectly indicate, although there are provisions that the arbitrators should be human beings. So human beings will be the arbitrator, in our real arbitrations. And lastly, because different jurisdictions have different diverse attitude to AI, so we must face up to the challenge of the enforcement in different jurisdictions. So that is my brief conclusion about AI. And next, well, because I prepared my slides, so and maybe I will shift my seat. Okay. Well, from the perspective of arbitration institution, China's arbitration sector has undergone rapid development over the past decades. However, when penalty cannot be replenished promptly, the surge in the number of cases places immense pressure on the case management of these institutions. This scenario is mirrored in SHIAC, and let me give you some details about that. In 2013, almost 10 years ago, SHIAC accepted only 397 cases with a dispute amount of 3.9 billion yuan. Last year, however, SHIAC accepted 4,879 cases with a dispute amount totaling 70.8 billion yuan, both of which surpass our historical highs. In addition to the explanation and increase in case, the rapid advancement of technology also presents challenges to arbitration institutions. In the post-pandemic era, most mainstream arbitration institutions worldwide have embraced technology to bolster case management efficiency. For instance, SIAB issued the framework guideline on the use of technology in international arbitration in 2021. This guideline aims to encourage different tribunals and patients to conduct virtual hearings based on 4 key points. The first one is proportionate, and second one is fair, third one is transparent, and the last one is secure use of technology. Clearly, the importance and necessity of discussing technology empowerment cannot be overstated. Furthermore, it's essential to shift our focus from external challenge to the internal motivation within arbitration institutions. The main motivation is compelled by party-centered conception, which donates the practice and improvement of management efficiency. Meanwhile, arbitration institutions are expected to proactively enhance case management efficiency by regulating the bad faith behavior parties. These dual challenges, and coupled with the drive for improvement, motivate arbitration institutions to innovate and continuously enhance the practice. So next, I will share a typical case in SHIAC. The case administered by SHIAC served as a fitting illustration of these points. In almost 2 years ago, SHIAC accepted a pharmaceutically enterprise entity transfer case with a dispute amount reaching 23 billion yuan, setting a new record for the individual case among Chinese arbitration institutions. The core issue revolved around an investment agreement where the parties agree that the respondents would complete the acquisition of the target company's equity in 2 stages. However, the second stage, involving the respondent purchasing the equity at a value corresponding to the target company's 2020 net profits, faced a significant change. The unforeseeable surge in the target company's net profit, driven by the COVID-19 pandemic outbreak in 2020, present a non-commercial risk-related circumstances, constituting a change of circumstances beyond the anticipating of both parties. So in this case, we conduct via virtual conference with all case materials served online. Yeah, throughout the arbitration procedure, the tribunals issued a procedure orders several times to expedite the process. Yeah, after two hearings, multiple rounds of mediation were conducted, leading to both parties agreeing to withdraw their arbitration request. Ultimately, the dispute was settled. Yeah. So in light of the aforementioned case, the significance of technology empowerment and the integration of arbitration and mediation and the tribunal's procedural management authority in achieving high efficiency case management becomes evident. So in the remainder of my speech, I will delve into each of the 3 aspects more specifically. So, because SHIAC also introduced our new arbitration rules at the beginning of this year, and the first one I want to emphasize is to explore the use of technology to empower high efficiency case management. Yeah. Under this new arbitration rules, we have given priority to the electronic submission and as well as the service of documents, reflecting SHIAC's commitment to leverage technology for streamlined and effective case management. So besides, we also launched similar practice as CTAC and other arbitration institutions. We also launched the SHIAC e-platform last June. So this platform offered various functions such as online case filing, electronic document exchange, online hearings, and digital signing of documents and awards. Yeah, we also can easily achieve the objectives of green arbitration and expanded procedures. Yeah, since its launch, we have widely embraced and utilized. Till now, the platform boasts almost 1,100 arbitrator registrants and 8,000 party registrants. The introduction of SHIAC e-platform signifying a milestone in our commitment to a party-centered approach to the promotion of intelligence arbitration practice. So the second one is about the integration of arbitration and mediation organically, to resolve disputes at the early stage. So in almost 10 years ago, we launched the FTZ rules, which innovates the mediator-led mediation system. So which is the mediator is separate from the arbitrator in certain cases. So in this version of rules, we have it has become a practice in our general rules. And aside from this practice, we also innovate some new practice, because we note that because the Singapore Mediation Convention has taken effect, we try to our best to have a hybrid of arbitration and mediation. And then if the settlement will be agreed by the arbitrators, it could be, it will be transferred to the settlement agreement and secured the successful recognition and enforcement under the convention. Yeah, aside from the general rules, we also have the specific rules, like the aviation arbitration rules and the data arbitration rules, yeah, to respond to the dispute resolution. Because we introduced the prior mediation before the arbitration and help the parties to management their risks, yeah, in the arbitrations. So the last but not least part is about the regulating acts of bad faith in arbitration, yeah, to guarantee the smooth proceeding of arbitration procedures. So integrity is a key point of arbitration. So how to promote and safeguard the reality, the integrity of in arbitration. In our rules, we respond to the question by encouraging procedural management approach, such as procedural orders, yeah, like the pre-tribunal meetings. But in this section, and we have some new innovates. Like we strengthen the arbitration tribunal's power of procedural control and empowered the tribunals to regulate dishonest arbitration behaviors. So take some instance, under our rules, parties should participate in arbitration in accordance with the principles of honesty, good faith, and cooperation. At the same time, tribunal can decide whether to agree to the parties' request to change or add representatives to participate in the arbitration proceedings, yeah, refuse to consent to withdraw and continue the arbitration proceedings, or to allow the opposing party to make a counterclaim for arbitration fee, costs, yeah, already incurred if consented to withdraw is granted. So by regulating dishonest arbitration practice and ensuring the ordinary conduct of arbitration proceeding, arbitration institutions, yeah, enhance the internal driving force for improving case management efficiency. To sum up, yeah, how arbitration institutions conduct efficient case management, I think it is an enduring controversial topic, and it is also a manifestation of core validity of arbitration institutions. I hope today we could inspire yeah, our brainstorm, yeah, allowing us to explore new patterns and methods, yeah, for improving management efficiency. Thank you.
Thank you, So-Seng, for very quite high efficient introduction. And one point impressed me is, or make me feel very interesting, is that she mentioned regulating acts of bad faith in arbitration. So this occurs to me in the real case, in real practice scenario, how to differentiate bad faith in good faith, or at least non-bad faith. I think between good faith and bad faith, there's some gray area. So you, as most of the audience know, actually, when the users choose arbitration, they have an expectation to resolve the dispute in a highly efficient way. But in practice, actually, in probably one party, they hope the case will not be run in such quick pace, and they even use some tactics to delay or to the procedure. So this is a question for So-Seng and also for all my panelists. So what do you think of this kind of phenomenon? And in your what's your position from the perspective of arbitration institution? Do you, especially internally, what do you have, how to handle this kind of tactics? So maybe start from So-Seng.
Okay. Well, thank you for the questions. Well, I will try my best, yeah, to answer. Okay. Yeah, because actually, this is a new well, this is a new regulation of SHIAC, yes. And but honestly, I think that's yeah, similar picture or scenario, yeah, in our previous practice. Because I note that in some awards, yeah, the tribunals, yeah, will have their attitude, or maybe to have the discretion, yeah, to allocate the penalties. So I think that is the practice, yeah, before the specific regimes, yeah. So this is my yeah, my sharing, yeah. Okay.
So if I may add something here, so first of all, I have to say that there is no provision in our rules that if there is bad faith and that allows us to not proceed with the arbitration, we definitely do not do that. We have to proceed with the arbitration. But I think that so arbitration is definitely not the party's destination, but resolution is. So in such circumstances, we have to look into the party's need, and sometimes parties cannot reach an agreement on a single thing. But in such circumstances, we have to look what parties agreement are reached. I mean, the agreement reached between the parties. And as counsel at HKIC, I have to say the art of my work is to communicate the junior, communicate the case manager with the managing counsel, with the Secretary General, with our ACPC, and external. I have to communicate with the parties, with the tribunal. And that's why I am of the positive position that AI cannot take my job. So I think my stop here. Thank you. That's my understanding.
Luis, yeah.
It's an interesting question, but first of all, I have to put it in context. I don't think bad faith is something we see in the majority of cases. There are outliers, but basically in international commercial arbitration, we're dealing with professional firms, professional people, experienced arbitrators that are there to resolve a business dispute, and they act accordingly, and they're very deferential to each other. Now, having said that, there are cases that are problematic. I have one that is going right now, which has tested the arbitral tribunal in all ways that one can imagine. And that's my response. It really is a question for the arbitral tribunal to use its judicial demeanor to understand that it has a duty to keep the arbitration moving forward. And if they have a party before them that's engaging in dilatory tactics, is not complying with the tribunal's orders, it is trying to go beyond the boundaries of the rules, well, the arbitrator will try to keep the party on track, but at the end of the day, it will enforce the rules, it will comply with its mandate. And I've seen the arbitrators, they have the possibility of sanctioning the party. They can certainly take into account their behavior when they're allocating costs. And, you know, sometimes I've seen a party that may prevail at the arbitration, but they've had some questionable conduct during the arbitration that when it came time to allocate the costs, the arbitrator, instead of giving them 100%, maybe gave them 40%. Because of their conduct during the proceeding. So the arbitrator has a lot of tools, and good, trained, sophisticated arbitrators can manage the case and deal quite efficiently with a party that is engaged in bad faith, which is obviously a very broad categorization, if you will. But it reminds me of the Supreme Court saying about when they recognize obscenity. They know it when they see it. Well, bad faith, the institution knows it when they see it, the arbitrators know it when they see it, and they'll behave accordingly.
Yes, Dr. Chen, I also have a very brief comment about this question. So generally, I think the parties wish to move the procedures in a very efficient manner. But also, however, under some special situations, maybe it is possible that parties or even the tribunal would like to control the pace of the procedures and try to make the proceedings slower. I think usually, I think it's okay. I think if that situation exists, I think the institutional rules should give such flexibility or discretional power to the tribunal and let the tribunal decide. as an institution, just should support the tribunal to exercise such discretionary power, or according to the rule, the institution should even make such decision by their own, just to control the pace of the proceeding. So that's my brief comment. Thank you.
With regard to the bad faith, good faith issue, I agree with Fu Yong that there is no clear criteria as to what is bad faith, what is good faith. For example, appointing arbitrators, do you think it's bad faith or good faith? Generally, you will think that's the right of the parties. However, if one party keeps appointing the arbitrator that is in conflict of interest with the counterparty, do you think it's still good faith? Again, hiring your own lawyers is not bad faith. However, if you hire someone, if you add a lawyer in the proceeding who shall constitute a conflict of interest for the already formed tribunal, do you think it's bad faith or good faith? So it's a very complicated issue, but when you are faced with it, you will immediately know whether it's good faith or bad faith. Then the tribunal and the institution will jump in and do something. So that's why in our new arbitration rules, we allow the institution to exclude additional lawyers if such act will hinder or impair the already preceded procedures. So yes, everything I would say should be strike a balance. On one hand, we have to respect the parties' rights. On the other, we have the efficiency of administration at hand. We have to weigh the balance and see what is the best for the whole process.
Thank you for all the points from our panelists. And although Chunyan have made some comment, before I invite him to introduce the key revisions of SIAC's new rules, allow me to make an officially introduction of Ms. Zhang Chunyan. He is the head of China desk of SIAC and chief representative of SIAC's Shanghai representative office. He is responsible for overseeing SIAC's activities in China. Since joining SIAC, Chunyan has worked with key stakeholders of business and legal communities to promote the development of international arbitration and global best practice by organizing training workshops and networking events for in-house counsel, practitioners, and arbitrators. He is a frequent speaker on arbitration topics and conducts lectures and training sessions for arbitration users. He is a member of SIAC delegation, an Arbitral Working Group 2. He graduated from Renmin University of China and Peking University School of Transnational Law with bachelor degree, JD, and JM degree. He is qualified as an attorney in China. Prior to joining SIAC, he worked in a leading Chinese law firm in Beijing, handling commercial arbitration in related lawsuits. So now the floor is yours, Ms. Zhang.
Thank you, Fu Yong. On efficiency management and SIAC's practice on this point, so I would like to address this topic on three aspects. I think first aspect is about the rules. The current SIAC rules is implemented or become effective effective on 2016. That was 8 years ago. But even though it has been implemented for some years, it is a very good rule. Received very positive comments. This rule has included all the mainstream procedural tools like the EA, emergency arbitration, EP, expedited procedure, ED, early dismissal, and also consolidation, joinder, and other very popular procedural tools. According to our internal stats, we find that all these procedural tools are very popular and also very effective. In particular, the EA. I would say that from the stats of all SIAC cases, you can find that almost all EA cases, the EA arbitrator can be appointed within one natural day, not working days, 1 day, and all the EA order or decision or EA award can be issued within 10 days after the EA arbitrator has been or was appointed. Very effective procedural tools. Even though now SIAC is also trying to revise its current rule, which is the sixth edition of the rules. Now it is now completed, but according to the consultation paper of that rule, we can find that SIC is planning to introduce a new procedure, which is named as a streamlined proceedings. Under this streamlined proceedings, it effectively requires the tribunal to conclude the case within 3 months. And these proceedings applies to the cases under the Singapore dollar 1 million Singapore dollar, which is about 5 million RMB. And also to achieve these effects, the streamlined proceedings requires the arbitrator to decide the case on basis of written pleadings and evidentiary evidence only. And also only the sole arbitrator will be appointed for such streamlined proceedings. Generally, I think this new proceeding is very ambitious, and also we have received some very, some concerns from our users, in particular the users from the common law jurisdictions. For the users in common law jurisdictions, you will find that 3 months is too short. So it is almost impossible to complete the arbitration procedures. But from the perspective of the institution, we believe that we should provide the users with more options. Because for this kind of super fast procedures, this should be only applied to the very simple and straightforward disputes, and also the small amount disputes. But right now, the whole thing is now has not been finalized yet. We are still considering the comments and also suggestions from the users around the world. The second aspect I would like to address is about the people. As the theme of this year's ICAT conference in Hong Kong, human endeavor, I would say that the efficiency management is also a human endeavor. To achieve the procedural efficiency, we need to, I think first of all, the institution need to hire enough people to handle the case. Now, SIC Secretariat, we have 16 people in total. I mean, the registrar and the counsel, excluding all the case management officer, just the core people, right? We have 16 legal professionals to handle the case. These 16 people can speak 16 different languages. They are from 13 different jurisdictions. So right now, the average caseload of SIC is about over 500 cases. So therefore, each counsel only need to handle less than 50 cases every year. So which ensures that the counsel have enough time to deal with the case, and also have enough time to deal with some unexpected situations which need to be handled under very emergent situation. In addition to the counsel, I think the institution also need to appoint the qualified and also you can see the good arbitrators, which is very difficult, which is not easy because the good arbitrators are chased by different institutions and also by users. But SIS and also other institutions who are here today, we are the reputable institution. We are in a very good position in the market. Therefore, it would be maybe easier for us to appoint the good arbitrators to the case. Therefore, they can provide a good quality service to our users. And also, as a chief rep of SIS Shanghai office, so my job is also include to advise our users to use experienced lawyers, which is particularly important in China because the arbitration practice in China is quite different from those in the common law jurisdictions. So therefore, some of the Chinese users, in particular the inexperienced users, would tend to use the lawyers they are familiar with, but somehow they are not quite familiar with the practice of international arbitration. So this is very dangerous, and also will ultimately, is not good for the user's interests. So the counsel, arbitrator, and also the lawyer. I believe all the participants of the arbitration procedures are very important. Just they need to do their own part just to ensure that the whole procedures will be conducted in a very efficient manner. third aspect, also the final aspect I would like to address is about the technology, which was also mentioned by other speakers. The technology is very important. I think before we adopt any advanced technology like AI, the first thing we need to do is to try to adopt the paperless workflow, which is also quite important for the Chinese institutions and also the Chinese users. Because right now, some Chinese institutions are still quite heavily relies on the paper bundles, which of course, obviously, it would become an issue when they start to use technology. Now in SIC, I have spent in Singapore in April for 3 weeks. My desk is in the Secretariat's office, so I can see that now in SIC you cannot find any case bundle in our office. So everything is on our cloud drive. Every console is working on the electric files. And also our users are required to initiate the arbitration by sending us emails or just through some cloud drives if the document is very large. I also agree that we are now in the AI age, we need to consider to deploy some very useful AI tools. Now I think the consideration is largely about the data security. In particular, for the AI tools like the ChatGPT, it basically requires the users to upload the valuable data to the survey outside the company. Then you can, only through this channel, you can get the result you want. So maybe for the legal sectors, like the institution and law firm, I think the management will prefer some localized AI tools, which I'm not sure whether such localized AI tools is available on the market. But if it is, I think those localized AI tools would be more preferable and also address to the concerns of data security of the management. But in the end, I think the institution is a consumer of the technology. We're not the inventor of the technology. We just need to rely on the big tech or some boutique legal tech firms to develop some very useful tools for us. So only at that point we can deploy these tools to promote our efficiency. So I'll pause here. Dr. Chen, that's my comment.
Thank you for the introduction. I see one of the new development is in your new rules is the application for emergency arbitrator may now be filed prior to the filing of the notice of arbitration. So one question come to my mind is, how about your statistics about the application of emergency arbitrator? And do you see the distribution in different proceedings? I mean, what's the percentage occurs in the expedited procedure or in the normal procedure? But now you still have no practice of the streamlined proceedings. So this is the question for Chun-Yan. And for other panelists, I know actually the emergency arbitrator is become a normal practice in most international arbitration institutions. But I know it is inaugurated from AAA. If it is kind of innovation, it is innovated by AAA, I think, to my knowledge. So I also would like to ask all the panelists to share their new development on or practice on emergency arbitrators. Okay.
Thanks, Dr. Chen. I think this question just highlights the importance of using AI tools. If I have the AI tools, I can just, just to search our internal database, just give you the answers. And my apologies, we have the stats on the special procedures. We have recorded the numbers of applications and also the numbers of SIC decisions. Maybe I can share those stats with you and the other audience after the events, if you are interested. So I just reserve the time for other speakers to request them to share their stats.
Luis.
Well, thanks. It's one of the most successful initiatives that we had undertaken, and we did a thorough review, and we did this in 2006 of why we thought this would be beneficial, because it was consistent with the parties' wishes to stay within the arbitration framework. Prior to having this tool, you'd have to go to court at the seat where the arbitration is taking place and seek judicial determination regarding the emergency relief you were seeking. Once introduced, you could stay within the arbitration framework. So our rules allow you to have access to an emergency arbitrator at the time of filing. When these requests come in, we immediately initiate the case and proceed with the arbitration. In our case, the next step will be the mediation, followed by the arbitration. But on a parallel track, we'll appoint the emergency arbitrator. Within 24 to 48 hours, they'll clear conflicts. We do everything telephonically. We'll have a remote hearing. The emergency arbitrator will set an accelerated schedule for submissions. They'll make a determination as to the emergency application. They can do it as a partial award. And the rule has teeth in that if the parties do not comply with it, the tribunal later on can see what transpired during the emergency phase. The tribunal has the power to modify, vacate, or leave the emergency order in place. So it is very successful. I do have statistics. Up until December of 2023, since we started, we've handled 160 of these cases. 73 of the emergency applications were granted. 41 were denied. And when they're denied, the primary reason is that the emergency arbitrator felt it was not emergent. It could wait for the tribunal to decide it later on the case. 24 were settled and 21 were withdrawn. So very successful mechanism. I did, since we're coming to the end, wanted to say one of the important roles that institutions have is introducing innovation in these technologies, and very happy when they work. Sometimes they don't work. For example, the previous panel discussed appellate procedures in the ISDS context. We received a lot of feedback that we should have a set of appellate procedures for international arbitration from our users. We did that in 2013. To date, I probably have only had 6 cases. They were screaming for these procedures. They're in place. We had a special panel. It is very well drafted for the appellate arbitrators to look at possible errors of law or conclusions of fact. Great process, did not work. So there are times that they work, there are times that they don't. We all have an interest in constantly improving our processes, and that's why it's important that we share these ideas and exchange our experiences.
Thank you. Do you have some point to add?
Yes, thank you. So in one short sentences to explain the emergency arbitrator proceedings, that HKIC has to appoint the emergency arbitrator within 24 hours of receiving the application, and the application deposit currently is 250,000 Hong Kong dollars. And the emergency arbitrator has to render the emergency arbitrator decision within 14 days. She or he only have 14 days to render this decision. And I would also love to share my personal experience in handling one EA application just 1 week ago. That's a very savvy time period because majority of the Hong Kong and the mainland arbitral community came to Hong Kong for ECA. So I was so stressed. And the deadline for the EA decision was 8 May 2024. So that case, the language of that case is Chinese. The governing law of the marriage is Chinese PRC law, and the governing law of the arbitration agreement is Hong Kong law. Parties came from Hong Kong and the mainland, and all legal representatives of the parties located in Shanghai. So when identifying the suitable candidates, our approach is to consider the availability of the candidate, especially whether he or she came to Hong Kong for ICA 2024, or whether he or she has any speaking engagements during that period. So fortunately, we appointed a senior, experienced, suitable candidate for these emergency arbitrator proceedings. We even have one-day hearing for the emergency arbitrator proceedings in Shanghai at our HKIC Shanghai office, and we rendered the decision 2 days before the time limit. Finally, there comes to the statistic sharing. Since 2013, HKIC has handled 38 emergency arbitrator procedure applications. That's all from me. Thank you.
Thank you. So do you have some?
Well, emergency arbitrator, I was not aware that it was a AAA convention, so I would thank AAA for such good thing. Yes, well, I think it works very well, especially for cross-border disputes before CTAC, because, you know, the enforcement is an issue in mainland China, whether if it's still in the nature of interim order or interim relief. So such power is still dwelling with the court. However, if it's a cross-border dispute, then it can be enforced, you know, in a jurisdiction out of China. For most of the emergency arbitration accepted by CTAC is either on the seizure of assets or the, you know, the prevention of the liquidation of a bankrupt company. Well, I would say that most of the cases were granted. I mean, they relief. However, I recently know that there was one case denied, probably because of it's not emergent enough. What I would like to provide you, I mean, for your information, the CTAC has only 1 day to appoint the emergency arbitrator, who shall make the decision within 15 days. So it sounds like mission impossible because that's under such time stress. However, all of the emergency arbitration proceedings have been performed very well so far. So that's how I would like to provide.
Thank you. So, Sam, do you?
Yeah. Well, thank you for the question. I think that's our understanding. Arbitration peers have rich experience in EA, and I want to share some ideas from my side. Well, from SHIAC, because we have paid a close attention to EA and interim measures, which could trace back to 10 years ago, which is stipulated in our FTZ rules. And I think that the biggest challenge is the precondition of EA is how to judge the urgent. But the similar idea, like Fei said, that I think it is very it is a little bit hard because in China because we have the burden or the duties will be on the courts, And in our new the third one is in our new arbitration rules, because we have the aviation arbitration rules. We note that in the aviation industry, because the preservation of aircraft, well, based on the Cape Town Convention, will be the precondition in the aviation industry dispute resolution. So in our aviation special rules, we have innovates the interim measures as well as the EA in the specific area. And the last one, I think it is very interesting, is because we are preparing some materials for the ICA, and we found that almost 30 years ago, at the beginning of 1990, we have a case, applying the interim measures rendered by the tribunal, So in which the respondent involved the liquidation in Hong Kong, and the tribunal rendered the decision on injunction, per the request of the claimant. So I think that EA and the interim measures had very common ground, in our practice.
Okay, thank you for the update on the EA. I know we only have several minutes there, and I also know for the audience, maybe some curious, how about BAC's practice on this topic, right? How BAC do to improve the efficiency. So allow me to take several minutes to share with you statistics. Over the past 3 years, on average, BAC, the duration for the case administered by BAC is 179 days from the filing of case to the closure. And also, if you calculate it from the constitution of the arbitral tribunal to the conclusion of the case, on average, it is 100 in 5 days. So very high efficiency, high efficient. And you may further ask, how does BAC to achieve this high level of efficiency? So first, we, like other arbitration institutions, we also heavily rely on our case management system, and also have the electronic signing, etc. But another 3 measures BAC took to encourage the arbitrators to raise the efficiency, including first, limitation on arbitrators' caseload. According to BAC's internal provisions, also the code of ethics for arbitrators, an arbitrator is not allowed to accept a new appointment when there are 10 or more pending cases under his or her name. So this requirement encourages arbitrators to conclude their cases as efficiently as possible so that they can accept new appointments. Second is the availability requirement. That means if the arbitrator may not be available for a first hearing within 60 days after the conclusion of the tribunal, he or she is not allowed to accept the appointment. The third is prompt delivery of the award. That means the presiding arbitrator is expected to provide the draft award within 30 days from the last hearing or the last submission of the parties, and the co-arbitrators are expected to provide comments within 5 days of receiving the award. An arbitrator with undue delay in more than 3 cases in the arbitrator's history of arbitrating with the BAC will not be offered new appointments from the arbitration institutions for 1 year. And those with serious undue delays will be removed from the list of BAC arbitrators. So this is some information from BAC, and I know I have run out of the time, although I still have many questions to ask my panelists to learn from them, but I have to wrap up this section. So ladies and gentlemen, please join me in thanking all the contributions of our panelists. And also a big thank you for all the audience for staying with us until now. Thank you. Yeah.